I don't know too many journalists who signed up for to work in this field and thought that they would have to cover this.
Right. I didn't think I'd ever say the word sitting in the slammer while campaigning for president.
We will never give up. We will never concede. It doesn't happen.
Mother Teresa could not beat these charges. And now, if you don't mind, I'm going to go into the icebox and sit for a long time. Thank you very much.
Welcome to Trump Trials Sidebar from the Washington Post. On this historic day, the Supreme Court has ruled U.S. presidents have absolute immunity for official acts, a ruling that has massive implications for the former president, Donald Trump, and his legal cases, and for the power of the American presidency. I'm your host, Rhonda Colvin. I'm joined with JM Rieger and also James Hohmann, who joins us from New York. Welcome, guys. We are, of course, this is a special podcast because of the magnitude of this case, so we're going to try to break it down as we've just read a bit of the decision. And remember, you can watch our show each week at youtube.com/Washington Post or listen to the audio version wherever you get your podcasts. But back to the big news. James, I'm going to start with you. I remember we sat next to each other when we covered the oral arguments for this case. And I'm just wondering, what's on your mind as you try to figure out what the justices have just done?
The justices saved the biggest and most consequential decision for last. It's the final day of the term, and we can dissect what the decision actually says, but it ultimately is a big win for Trump because it means that there's not going to actually be a trial before the November elections. It kicks a lot back down to the district court to look at the evidence and to make decisions, basically to triage this case. And it really did drag out the clock several months. The justices basically heard this case on the last day of oral arguments for the term. They put out their decision on the final day of the term, and now they're kicking it back to the district court. And essentially, it's not everything Trump wanted by a long shot. Trump wanted absolute immunity for everything, but it is in the realm of what prognosticators and Supreme Court watchers expected. It is very favorable to Trump. 6-3, the conservatives all joining Chief Justice Roberts. And basically they're saying anything that can plausibly be argued as an official act is immune from prosecution. So just right there, that's going to strike down a bunch of the charges in Special Counsel Jack Smith's indictment against Trump, because it means that everything Trump did with the Justice Department and Jeff Clark and trying to get the Justice Department to investigate made up allegations of fraud, that's all thrown out. It seems basically like everything Trump did to pressure Mike Pence in his role as vice president to reject certification is going to get thrown out. It'll be tested in the lower court, but it's very clear that that's where this is headed. And then all that really leaves left is the speech that Trump gave at the Ellipse, where he told people to go fight like hell, and he said he was going to go with them. And the justices created this test. This is a very long opinion that the lower court will have to dissect, but they're saying, maybe it was official, maybe it wasn't. You have to look at the context. And I think people will ultimately agree that the speech at the Ellipse was not in his capacity as president, but that's the kind of the least of the alleged criminal activity. So ultimately, this is sort of a decision for the ages because it affects every president, but it is a big win for Donald Trump.
And James, did you sense that the court and the justices kind of understood the gravity of what they were about to decide? That's how I felt when I was reading it, that it was very much about the wording. Was he an office seeker or an office holder? We remember, listening to them question that when they had their oral arguments. And then also, they're trying to figure out what's an official act versus an unofficial act. And you mentioned the example of, in the decision, they say his capacity discussing the electoral count with Pence was an official act because Pence, in the Constitution as vice president, holds an official role in Congress when it comes to January 6th and counting the ballots. So it seems like they really were mincing around some of the words and trying to figure it out. But does that also point to them knowing that what they are deciding has ramifications for the future of the presidency?
much. And the dissent from the three liberals, it basically says, look, democracy is in grave danger under the standard that the Supreme Court has just created to give this expansive reading of executive power. The hypothetical that came up in the lower courts where the president could order SEAL Team 6 to assassinate his political opponent, that would be covered because the military, any order you give the military is an official act. So the liberal justices are saying this really opens the door to widespread abuses of power in the future. And I think some of the grave language in the dissent reflects the sense of enormity. And it's fascinating because, as you know, Rhonda, we watched this case together, we listened to the oral arguments, and it did feel like maybe the conservatives would be a little bit divided. And the people like Kavanaugh and Roberts, who have worked in White Houses, would be more sort of open to executive power. But in this case, all six of the conservatives agreeing that so-called official acts, or making the claim of official acts, really gives you broad leeway to not fear prosecution. I mean, ultimately, this may end up redounding to Joe Biden's advantage next year if he's no longer president and Joe Biden is facing prosecution for things he did because Trump wants the Justice Department to go after him. It is one of those things that it does create this precedent that will apply to future presidents.
Yeah, what a world we are living in and covering. JM, I know this is all fresh. We've got the decision printed out here. We've raced down here to tape this podcast. Tell me what your thoughts are, your initial thoughts as you've heard this decision, as you've read through some of the pages. What's on your mind right now?
I mean, piggybacking off what James was just talking about, this is a redefining and in a lot of ways an expansion of executive authority here. Mm-hmm. It's a remarkable decision. As James was just saying, we heard Justice Neil Gorsuch say during oral arguments in April that they were writing a decision for the ages here. So I think they knew the gravity of the situation, but the language in the opinion is really striking. Justice Sotomayor writes, quote, "With fear for our democracy, I dissent." This is the ramifications of this, the tail on this decision will be felt for likely years and years into the future here. And from a political standpoint, we've been talking so much about kind of the fallout of the debate just a few days ago. And this feeds right into kind of Trump's campaign strategy here of delaying these trials for as long as he can. And when it comes to the January 6th case in federal court here in D.C., and the Supreme Court today is telling that court to re-examine now with this new framework, that likely pushes this beyond the election. And again, that matters because if Trump wins re-election, he could then instruct his Justice Department to toss out these charges.
And James, before you go, I want to get both of your opinions and thoughts and reporting on this. Where does this take us politically? We know that this is not a clear-cut win for the former president, but we do know he often takes things and runs with them. Where do you think we're going with this?
Yeah, Trump has already posted on Truth Social minutes after the ruling that this is a big win for our Constitution and democracy. In his words, he's going to claim this is vindication. He's going to say, John Roberts is no friend of mine, and he wrote for the court. And this is about executive power generally and the power of the presidency. And this is. I think it's a political victory for Trump because it does just delay everything. It means that he's not going to have some October trial in D.C. where he's out of the campaign trail. And the Judge Eileen Cannon in Florida is doing everything she can to drag her case out. The Georgia case has been postponed because of appeals over Fani Willis and whether she should be disqualified. Obviously, we have sentencing coming up in a few weeks. But if you're Donald Trump this morning, you're feeling really good coming out of the debate, getting this ruling, and then he has his VP to roll out sometime in the next 2 weeks. So I think Trump has to be happy.
All right. Thanks so much, James, and we will see you soon back in the studio. So, JM, picking up where James left off, the politics of this, we know Trump usually will take something and run with it. Where do you think this goes in terms of the campaign and how this decision affects the campaign?
If this decision wasn't already monumental enough, it feels like it just got that much more important coming just a few days after what was an awful debate for President Biden, with the potential, we don't know yet, but with the potential to really change the dynamics of this election. This is yet another wrench in what so far has just been an unprecedented kind of campaign cycle that we're talking about here. I also am interested how this impacts, if at all, Trump's vice presidential selection. He sort of said that he sort of hinted earlier this year that he had already made his mind up. We know that, and you were down in Atlanta, and he had a lot of his vice presidential contenders, or who are thought to be vice presidential contenders, down there as surrogates for him. But a central question in that selection is whether they would have certified the election as Mike Pence did in early 2021 for the 2020 election there, because that does show up in the opinion here. The quote from the opinion is, other allegations such as those involving Trump's interactions with the vice president, state officials, and certain private parties, and his comments to the general public present more difficult questions. This coming in the context of how much of the quote-unquote outer perimeter of his official acts is he immune from, but the court taking a very kind of broad view of that today.
Yeah, it's so interesting because I don't know if there is another time in history where the preceding election is still playing out months away from the next election. So, yeah, good point about the vice presidency and his pick there. Well, coming up, we will have our colleague Blair Guild, who is in front of the Supreme Court, to give us some color of what it's like right now as this decision has come down. So stay with us. Our colleague Blair Guild is in front of the Supreme Court as this decision has come down. It looks like people are gathered there. Blair, what are you seeing? What are you hearing?
Yeah, so we got here pretty early this morning, and there's been a steady trickle of folks coming in, less of a protest scene and more of people who have kind of been anticipating this massive historic case. You're seeing a bit of folks on both sides of this issue, kind of some of Trump's supporters and those who are hoping for maybe a different outcome here today. So I'm seeing kind of a gaggle of some MAGA hats who are pretty happy with today's ruling, but I'm also seeing a few signs up, a few classic protest signs reading, you know, we elect presidents, not kings, and Trump is not above the law. So this highly anticipated case has really kind of gathered a crowd, as you can see behind me, but it's a lot of media, this being the last day for Supreme Court decisions of this session. It's a pretty highly anticipated moment. And an interesting thing that I'm finding in all of this is just, you think about the crowd that's gathered here versus kind of the crowds that are at Trump's rallies and campaign events. And this case in particular has been a rallying cry for the president. He has used this as a massive campaign issue, saying, if I don't have full immunity, if I don't have immunity, then that sets a precedent for presidents going forward and future administrations who won't be able to do anything, according to Trump. So it's an interesting contrast to see that kind of rhetoric at the rally and the crowd that draws versus the folks who we're seeing here at the Supreme Court today.
Yeah, and Blair, this decision came out around 10:30 in the morning. Did you feel a sense of what was happening at that moment? Did security tighten up? Did, just explain the scene a little bit at the moment the decision came down.
Yeah, absolutely. So, classically, the Supreme Court has their barriers set up for big decisions around this. It's, a fencing that we've seen at decisions before. And the crowd definitely peaked around 10:30. In fact, the decision might have been a little bit later than folks were anticipating. So there was kind of an energy in the air, and excitement folks anticipating what could happen. There was security, but no major chaos or disruption or anything, just people who were waiting to hear this highly anticipated case.
All right, Blair, thank you so much for those takeaways.
Thanks, everyone.
We're back, and we now have a new colleague. Tom Jackman is joining us. Tom covers the courts and criminal justice for the Washington Post. Thank you for joining us on this day.
Of course. Let's go.
Yeah, let's go. Let's go. That's what the Supreme Court said this morning.
Yeah, man. Get this case moving.
You know, this case was brought because of the January 6th federal probe into the former president's actions on January 6th and subverting the 2020 election. So that's really the only reason this was a question in front of the Supreme Court. I want to play a clip for you guys to just tell me what you're thinking when you hear what federal judge Michael Luig had to say. He's a Republican federal judge, and he yesterday commented on the case. So I'm going to play it for you.
The former president has corrupted America's democracy, constitution, and the rule of law. And now, with the Supreme Court's almost interminable delay of the immunity decision, he's gotten away with it. America's democracy and the rule of law are the heart and soul of the nation. America's been the beacon of freedom and liberty to the world for almost 250 years now because of its democracy and the rule of law. And through his defiance of that democracy and rule of law, Donald Trump has, I've said previously, unsold the nation. The only redemption for this unsouling of America at this point is that Donald Trump at least be held accountable for what he has done.
Okay, so I want to get your thoughts on that. The former federal judge also said that Jack Smith should just bring the case whenever he is able to, whether it's in October or weeks before the November election, just bring it. So what are your thoughts on that?
I don't think that there's any danger of the case being brought any time before the election in terms of getting anywhere near a trial, because Judge Chutkan now must determine from the indictment which of these acts were official acts of the presidency, which are immune from prosecution, and which were unofficial acts, such as maybe, submitting a false slate of electors. Was that an official act? Was calling the Secretary of State of Georgia an official act? So there's going to be hearings that Judge Chutkan will have. I imagine. I don't think she'll just decide it on the briefs. I have to think, there'll be briefs, oral arguments, what's official, what's unofficial. And then when she rules, and she'll issue a detailed ruling, that will be appealed. That will go to the D.C. Circuit. Then the D.C. Circuit ruling will be appealed, and that will go to the Supreme Court. And we'll be right back with these folks to determine if, when he was tweeting, "Hey, everybody, come to Washington, we'll be wild," was that an official act? When he said, "Go to the Capitol and protest," was that an official act? There seems to be some unclarity about whether or not what he said and did that day were official acts. What about his interactions with Mike Pence and telling Mike Pence, "You need to, delay the certification of states"? Was that an official act? This opinion seems to contemplate yes. And so, if they started on this tomorrow with briefing on July 2nd, they would brief to the end of this month, and then we'd have oral arguments in August, and the judge would rule in September, and then it would go to the appeals court in October, and then there's the election. So I don't see any way that we get close to a trial this year.
It's really stunning when you lay it out like that. JM, I was thinking earlier, I talked to one of the Capitol Police officers when oral arguments happened with this case. I talked to him a day before and asked him how is he feeling about the case and the Supreme Court taking this up. The one thing he pointed out to me is that he couldn't believe how much they delayed the case. Like, this was not just about the question at hand of deciding if presidents have immunity from criminal activity or criminal prosecution. It was also something that they kind of kicked the can down the road. They could have taken this up early. Judge Chutkan, I believe, started in the winter with all of this.
Right.
And then the Trump side said, wait a minute, stop. And then they threw it to the appeals court, or threw it to the lower court and lost appeal. And then the Supreme Court says we can take it up. So, did they do more harm than good when it comes to the question of whether or not Trump will be able to be accountable for actions many people said he was central to on January 6th.
I just think it's remarkable that we are still talking about the 2020 election and the actions and alleged actions around that election 3.5+ years later here. And we're likely to be talking about it past the election, as Tom was just mentioning at this point. The other thing is this has been on hold since December, because that's when the appeal on Judge Chutkan's ruling on this question of absolute immunity was made. And to your point, Rhonda, by the time that the Supreme Court decided to take this up after it had sort of worked its way through the initial proceedings, that was the end of February, but they didn't schedule oral arguments until the final week of oral arguments in late April. And now they wait until the very last decision day to issue the decision. Those weren't necessarily unexpected per se, but the court can move fast when the court wants to move fast. The court moved fast with Nixon. The court moved fast with the Colorado 14th Amendment case. So there are situations where the court can move fast. And now, as Tom was just talking about, we're in a situation where it is highly, highly unlikely that this case goes to trial before the 2024 election.
There's something else to consider here, which is the Justice Department took 2 years to get going on this case. They, as our reporting has shown, were hesitant they didn't want to appear political. We don't want to look like we're taking sides here. And they waited and they watched the House committee do their investigation. They actually asked the House committee, give us your transcripts, give us the evidence you've gotten. Well, go get the evidence yourself, DOJ. You're the investigators. And they did not do that. They're the ones that created the initial delay in this, which is what puts us here in July of 2024, still with no answers.
Yeah, that's so true. The point about, they waited for the January 6th case, or the January 6th congressional investigation. Right. They worked the case off of that. They took their time, didn't want to seem hyper political. And now we're here, months before the next election.
Allowed the candidate, in this case Trump, to say they waited so that it would happen during the campaign season. Little hard to argue with him on that.
Yeah, that's true. And then there's also the, that kind of informal rule, the 60-day rule where the DOJ isn't supposed to bring, any sort of prosecution or steps to prosecution ahead of an election. I believe that's an informal rule that they often operate under. That also gives Trump an opening to say, if you bring this before the election, then that's election interference. So then that's more noise around all of this.
Yeah, in theory, it should not apply in the case of if Chutkan herself decides to move this case forward. But, there was also, I spoke with court watchers earlier this year about how this might play out. What are Jack Smith's options depending on how the court rules? And one of those options was maybe Jack Smith goes to Chutkan and says, hey, I know I've requested X number of weeks here. I think it was 6 weeks, give or take. I can cut that in half. I can do this case in half the time. Let's move it forward, right? That was one of the theories.
I can do this case in 3 weeks.
I can do this case in 3 weeks. Maybe I can do this case in a day. Who knows, right?
But keep going while we're
But to Tom's point, I think that's almost totally out the window now, because there's going to be so many layers of procedural motions, appeals, that I don't know. It just, at this moment right now, it seems very hard to picture how this case comes to trial before the election. I mean, maybe there's a window post November general election, but I mean, we're putting the cart so in front of the horse at that point. It's just so hard to say right now.
Something else that's unique to this case, which is typically in a criminal case, a judge makes a ruling and then that ruling lasts and the case proceeds to the end. Here, the case stopped because they felt, well, it's an issue of first impression. Can you prosecute a president? So now, when she's ruling on is an act an official act or an unofficial act, does that qualify for an interlocutory appeal, an appeal during the pendency of the case? I tend to think they're going to say yes. Again, it's a president. It's a case of first impression. So in a regular criminal case, she would rule on these legal issues and the case would proceed. And if she was wrong, you would appeal that later after the case is over. But and so, theoretically, she'll rule what's official, what's unofficial. Okay, trial time, but that's not this case.
Tom, how do you see this playing out, this decision today playing out when it comes to the other cases, the Florida federal classified documents case and also the Georgia case? Because I'm wondering if the Supreme Court has ruled that, there are some official acts and some unofficial acts, and lower courts are going to have to figure it out. Does that affect the ability for those cases to move forward if the defendant is able to say, well, I'm, immune, and you're going to have to figure out when the official acts are and when they're not?
I think absolutely. Certainly in the Florida case, I think we're going to see those arguments filed, see what time it is now, but soon. And I could see Judge Cannon being somewhat amenable to those claims. I could be way out of bounds on that, but she seems to like defense arguments. And so I think that throws another wrench into the Florida case. I think the same, federal law overrides state law. So it's certainly an issue in Georgia. I think it could definitely delay both of those cases, or at least require the judges in those cases to make findings. I don't know if they would then at the same time make a finding about, now the official acts here in Florida. Did you officially carry the box of documents into the bathroom? Was that an official act or an unofficial act? Hard to say. But I think that's going to be hashed out in that court now as a result of this.
Yeah, JM, it seems like it really gummed up the works of the other cases, or has the potential to at least.
Absolutely. And the quote, I'll just read briefly from the opinion in terms of what it says around this, which is quote, other allegations such as those involving Trump's interactions with the vice president, state officials, and certain private parties, and his comments to the general public present more difficult questions. So seem to be leaving the door maybe cracked in terms of where this might go, how this might happen. But you have to imagine that Trump and his attorneys are going to file every motion that they can in these cases, because that's been, in terms of stretching this out, because that's been a central strategy for Trump and his legal team, which is to delay these cases as long as possible, because with the two federal cases, again, if Trump is reelected president and come late January 2025, he can instruct his Justice Department to dismiss these charges and kind of brush these cases aside, the two federal ones.
Which he cannot do in Georgia.
Correct.
So that's the one, and he cannot do that with the concluded New York case, which the sentencing is set for next week.
Yeah, let's talk about that a little bit. The New York case, that one, began and ended,
yes,
and now we're into the sentencing phase. Do you have any insight on how that might play out next week?
Not really. I mean, I can make a reasonably educated guess like everyone else. In most cases, a first-time offender, as he would be viewed by the courts, his age, lack of prior criminality would likely not get him jail time. So probation, possibly home detention. Now, there are some people who have said, well, people who have been convicted in New York for falsifying business records have gotten jail time. And there's not really any great impact on anyone in terms of financial loss to others, people losing their houses or their life savings by the falsification of records. That didn't happen here. They were just records that did not reflect what that money was for. Okay, a violation, yes, but will it result in him going to jail? I would bet very strongly against that.
Yeah, JM, your thoughts?
I mean, there's a few different scenarios, obviously, right, in terms of there's kind of, you can run the gamut here of gets nothing. Maybe there's some sort of probation or house arrest, or he reports on weekends, right? Obviously, you could go to, he reports to jail, but we also know that this is going to go to appeal almost certainly no matter what the sentence is. So there are a lot of factors, and Mershon seems aware of the fact that we are in kind of the final stretch of the campaign here. And Trump and others, we even heard his former chief strategist in the White House, Steve Bannon, make this argument on his appeal, separate case, but that because of his advice to Trump, his centrality as a figure in the 2024 election, that his jail sentence, which he reports to today, should be postponed until after the election. So the election stuff, these cases just sort of hang over this entire election cycle here.
The other thing that Merchan could do, knowing that the case will be appealed, is say, I sentence you to 30 days, but your sentence is stayed pending the appeal. So he could give him time, and then if you had to serve time, the time would be after the election when the appeals are resolved. I don't think there's a lot of great appeals ground there. Some people do. I watch a lot of that trial. I do not. But just holding off the sentencing, the imposition of sentence until after the appeals are resolved would at least put it until after the election, so he wouldn't be sitting in the slammer while campaigning for president.
Yeah. Does it blow your mind that we are covering a campaign and all of these court cases and a Supreme Court now just ruling that presidents do have immunity from official acts all at the same time? I don't know too many journalists who signed up for to work in this field and thought that they would have to cover this.
Right. I didn't think I'd ever say the word sitting in the slammer while campaigning for president. Justice Sotomayor's dissent is similarly dark and very angry about how this happened, and seems like something she didn't expect to see when she took on the Supreme Court job, which was that this 6-person supermajority on the court has decided to discard precedent when they see fit.
Yeah. The one thing that I remember from the oral arguments that was a stunning line was from Ketanji Brown Jackson, who said, if we rule on this and give immunity to presidents, that means that we might make the Oval Office a seat of criminal activity. And it's that stark. It really is. And even though, it's summertime, there weren't that many people outside of the Supreme Court listening to this, it's still a stunning day, a really stunning day for history.
Sotomayor wrote, settled understandings of the Constitution are of little use to the majority in this case, and so it ignores them.
All right, that's all we have time for this week. Thank you, Tom. Thank you, JM, as well as James, who joined us earlier from New York. We'll be back here next Thursday for the sentencing hearing of the former president. That happens on July 11th. And that sentencing is the New York case where he was found guilty on all 34 counts in the hush money trial. And you can find more of our coverage on that case and others on WashingtonPost.com and in the Trump Trials newsletter. But for now, I thank my colleagues for joining me today. I'm Rhonda Colvin. See you soon.